Is now starting. All attendees are in listen-only mode.
Great. Hello, everyone, and welcome. My name is Janice, and I'm the managing attorney for the Low Income Taxpayer Clinic here at MBLS, and I want to thank everyone for joining us. Just a few logistical things ahead of time. We do have a box for questions, so if you could please put your questions in that box. We're going to hold them till the end of the session so that we don't disrupt the flow of things, but please feel free to put in your questions as you think of them as we go along here. I do want to thank everyone again for joining us, and thank you all for being MBL's volunteers. This first slide just tells you how you can find out about cases and how you can join us in applying all this great knowledge that you are learning today to our cases. So this is on our website here. This is our MBLS Pro Bono portal where you can find cases. And again, if you look at the top here, you'll see there are different color-coded areas of the categories, and we are tax, of course. And again, many of our clients are in the collection phase, so this OIC information can be very, very helpful. So it's a great opportunity to apply what you're learning today to this. And we also have great mentors and access to some really wonderful people in the comptroller's office to help us with these issues. So. Please follow us on social media. We do have some additional trainings coming up, as well as one on Thursday about liens in Annapolis at the Office of Frost & Associates, and one coming up in the fall at Pontius Law in Rockville. So we're looking forward to seeing you all there as well. So with that, I'm going to let our wonderful speakers introduce themselves and take it from there. Thanks.
Okay.
Go ahead.
All right. Well, welcome, everybody. My name is Andrew J. Maschas, since we're all friends, you can call me Jay. I'm an assistant director in the Controller's Compliance Division, which is located in Baltimore, Maryland. I'm very happy to be here with Melinda Dunmire, who is the assistant to the director of the Compliance Division.
Yes, and I have recently taken over the position of Ben Miller, which some of you may already know. I know that we have some seasoned practitioners on the line, and so I am the chair of the case review board, and so I pretty much handle the offers and compromise.
Ben Miller is now the chief auditor for our business tax field audit section of the Compliance Division. For those who are wondering where Ben went, and so if you have cases involving business taxpayers, you may hear from them again. Okay.
Oh, and one thing I forgot to mention is that Jay and Melinda have very generously offered to allow us to post these slides as well as post the webinar after we finish. So it will be available again for future review. So, all right, thanks. Are you ready for the next slide?
Yes.
Great. Oops. There we go.
Okay, so as an attorney, I always want to start out with what is the statutory authority for Maryland's Offer and Compromise Program? And currently, there's only two statutes that pertain to Maryland's Offer and Compromise Program. There's Maryland State Finance and Procurement Article 6-219 and Tax General Article 13-816. So unlike the IRS, they're not a robust statutory framework in place presently for our Offer and Compromise program. Turn to the next slide. Yep. It starts out with the general statute that applies to state agencies. And this is I guess, explains what some of our requirements for the Offer and Compromise Program with the Controller's Office. This statute states that the Comptroller may, and underscore may, settle a claim of the state that has been in arrears for at least 2 years. As we'll discuss later, there is a 2-year waiting period that a case has to be in collections 2 years before it can be eligible for an Offer and Compromise. And for those that have wondered why we have a 2-year waiting period, this statute states that it has to be in arrears for 2 years prior to settling a claim. And before settling a claim, the Comptroller's Office shall examine the claim thoroughly and shall be satisfied that the state could not collect the claim through legal process. So this portion of the statute guides our review process. We have to be satisfied that we could not actually collect on the debt through other process before settling it. And the statute also, the important part of it, to settle a claim so as to best serve the interests of the state, the comptroller may abate wholly or partly the principal interest that is due to the state. And that's a direct language from the statute. And I note on this statute that it says best to serve the interest of the state. We don't currently have a statute that says to best serve the interest of the taxpayer or the public, but it simply references the interest of the state. And it doesn't discuss penalties, but inherent with settling a claim of a tax or tax interest and penalty, that we obviously have taken the position that we have statutory authority to compromise a penalty that's due as well. If we've settled a claim without the full payment, we're required to keep a record that states the facts on which the settlement was based. If we're accepting an offer in compromise and settling a tax debt, we do keep a record of those offer and compromise applications that come in for review. And we do keep those records in the office of the Comptroller's office, not my office or Melinda's office, but we certainly have it at the state. So this is the statutory framework in which we operate, in which our offer and compromise program operates. And within the tax general article itself, we do have a similar framework here. It's 13-816. If a tax under this article is not paid when due, the governor, tax collector, or treasurer shall ask a qualified attorney who's a regular salaried employee of the comptroller or attorney general to bring an action against the person responsible to pay the tax, unless a lien on real property sufficiently secures the tax or judgment in the action would not be collectible. So we don't pursue every tax debt through a legal action. This speaks to the fact that that there is if we have a lien placed on a tax debt, or as a result of a tax debt on real property in the state, that's sufficient. So we typically just simply secure our interest with a tax lien. Part C of this, if the attorney or attorney general and the tax collector agree that the full amount of the claim is not collectible, the attorney may compromise the claim, accept a lesser amount, and issue a release of the claim. So this is our statute within the tax general article procedure governing our disposal of a claim or compromising a claim. So these are the two sole statutes that we have. We've not currently issued regulation for offer and compromise program. Our information on the offer and compromise is available through our website, and that's our framework for the program.
And the purpose of the offer and compromise program is to resolve the tax liabilities with the comptroller when the taxpayer is unable to pay in full, and all other efforts to resolve the liability have been unsuccessful. I want to stress that it's when the taxpayer is unable to pay in full. You may have a taxpayer who has assets and is comfortable, and paying the tax liability would not result in any type of hardship, but perhaps they want to submit an offer and compromise, and just because they want this to be done with. I've heard that a few times before, and that's not the purpose of the program. We do verify that the taxpayer is unable to pay in full, and as far as all other efforts to resolve the liability have been unsuccessful, the purpose of this is not also to allow the taxpayer to file an appeal, or if they disagree with the tax, still not what we're looking for. And so then all the taxes that the comptroller administers, sorry about that. First time, sorry guys. All the taxes that are administered by the comptroller's office are eligible under the program. That includes our sales and use, the individual income tax, admissions and amusement tax, the corporate income tax, the withholding tax, and even the tire recycling fees.
And you just had that case, an application for tire tax last week. You know, you put together a slideshow and something changes in life.
Okay, and then once again, it shows on the bottom that the offer in compromise is not an appeal of the tax liability.
Okay, so with the statutory framework that we have in place, these are eligibility requirements that the Comptroller's Office has mandated many years ago, and I've been with the Comptroller's Office approximately 12 and a half years, and these have not changed since I've started with the Comptroller's Office at that time. Okay, so there's a number of eligibility requirements. The taxpayer must have incurred a delinquent tax liability that has resulted in assessment. It has to be a tax liability, and part two, it has to be an assessment. It cannot be an unassessed tax, and it cannot be a offer in compromise or some sort of appeal of a refund denial. And we do have some liabilities that do not result in an assessment. For example, if a business taxpayer files a balance due withholding or sales and use tax return, that may be shown on the tax computation notice or statement of account or a bill. It will not result in an assessment until we've actually assessed an officer for that, the responsible officer for the unpaid liabilities of the business. And it cannot be a premature tax computation notice or something that has not ripened into an assessment on for individual income tax. Okay, so the taxpayer must have exhausted all other avenues of administrative appeals. The taxpayer cannot be have an open appeal either through our hearings and appeals, which is an administrative hearing, or cannot be open in court. It has to have some finality to the assessment and to the appeal. Once it's the assessment has been fully litigated or fully appealed, then we can file an offer in compromise. We do not accept offer in compromise while something is pending. And I guess I'll move on to the next one because my comment, I have one comment about appeals. The taxpayer cannot make an offer in compromise if there is any issue remaining that can be appealed. This requirement does not state that you must appeal. For example, if you do disagree with one item on it, an item or items on the underlying assessment, you're not required to appeal those and reduce the liability to the amount that you believe it should be. There's certainly think that you weigh the cost, time factor of doing so. For example, I think if there's something that's a de minimis amount of money that can be appealed, it may be preferential to file an offer in compromise and try to seek relief if the facts are in your favor on that. But if you believe that there's ultimately that the assessment will significantly change or be rescinded based on an appeal, then you should go that route. Okay, 2 years must have passed since the taxpayer became liable for the tax. The 2-year requirement obviously comes from that statutory statute under finance that I first get on the first slide, State Finance and Procurement Section 6-219, and that's where it stems from. There has been some questions about what is the date that a taxpayer became liable from the tax? Is it the due date of the return? Is it the date that the return should have been filed but was not filed? Is it the date of the assessment? Is it the date of the notice notice of tax lien. We have not issued guidance on that particular item, but I believe that a fair interpretation of that would be a date of the assessment. There certainly could be unfiled returns, which we did not know that the taxpayer had not liable for. We'll talk about how you deal with a combination of assessments and unfiled returns, but I think it would be a fair interpretation that the taxpayer became liable for a tax when it was assessed either through audit or filing a balance due return or an IRS adjustment, or there was a non-filer assessment. Okay. The taxpayer must be current with respect to all return filing requirements with the Comptroller's Office. This is a requirement that does trip up a lot of low-income taxpayers and certainly individual taxpayers in general, because you will see that in many cases with low-income taxpayers, there may be a combination of balance due returns, unfiled returns, non-filer assessments, and how do you handle that? And because one of the problems with the 2-year requirement, 2 years must have passed since the taxpayer became liable for the tax, and then being current with all return filings is, well, if there's an unfiled return and I file that return and then there's an assessment generated, then it starts the clock running. We're going to talk about our hardship liability write-off program and how that might be the best solution for a taxpayer in that situation. The taxpayer must not be currently involved in an open bankruptcy proceeding. Again, we want to have finality to the assessment. So if there's an open or pending bankruptcy, the assessment may or may not be discharged because of that. So if we would reject offering compromises while there's an open bankruptcy. If something has been discharged, obviously, I don't believe there's a need for it to file offering compromise with it. If it hasn't been discharged, then yes, I think they're offering compromise may be the correct solution in order to get some relief with it. Taxpayers are unlikely to be able to make payment in full anytime in the foreseeable future due to the taxpayer's financial situation. We'll talk about the reason for OIC and maybe the economic or the hardship option, where a taxpayer may have the ability to pay in full, but that would cause a significant financial detriment to the taxpayer for certain reasons. Taxpayers either without resources or unable to apply present or future resources to paying the outstanding tax liability. Again, often our question about offering compromises is, does the taxpayer have the ability to pay the liability in the present or in the future? And if there's no ability for the Comptroller's Office to collect on this tax liability, then generally we should accept that offering compromise.
Okay. And submitting an offer in compromise is relatively easy. The forms and instructions are available online. You can get them at www.marylandtaxes.com or at www.marylandtaxes.gov, which is where is, I guess, the newer site where the comptroller is publishing more information. There are 2 sets of forms. The first form is the Form 656, and the second form is the 433A. That's the collection information statement. The 656 form itself is the application. It identifies the taxpayer. It typically identifies the reason that the taxpayer is submitting the offer in compromise, that is their circumstances, and it also lists what they are offering. The collection information statement is the taxpayer's financial information. So that's where they'll report their assets, their monthly expenses, their monthly income, and that's what we'll be reviewing when the case review board meets and makes a determination on the application. Now the offer and compromise form, which is Form 656, as I stated before, has information that identifies who the taxpayer is. So we have the name and address of the taxpayer, their social security number. If this is a business, please enter the CR number or the EIN. Also the tax type and the tax period, and also the reason for the offer and compromise itself. Some people submit an offer and compromise. There are very few because most of them go through the appeals process. And even those that have gone through the appeals process do sometimes submit an application for doubt as to liability. That is, they believe that they don't owe the tax that's due. And then the obvious reason.
Yeah, one comment on the doubt as the liability. Yeah, it shouldn't be used as the second bite of the apple as far as an appeal. It's not something that we would consider. Typically, this happens where a taxpayer has a liability that has significant age on it. It could be a non-filer assessment or some issue with the IRS, and they do not have the documents, but they don't believe that they actually owe the liability. But time has passed, and they're unable to actually present a credible appeal of the liability.
Okay, and then the other reason for submitting an application is insufficient resources. The taxpayer simply doesn't have enough assets or income to pay the full amount of the tax due. And then an economic or other hardship. So, for example, if the taxpayer were able to pay the full amount, but that would result in a significant detriment or severe hardship to the taxpayer, we want to know that. And
I think the typical situation may be a person may have equity in a home where they could sell their house, pay off the tax liability, but then they would actually have nowhere to live. And they may be in retirement age and therefore have to pay rent, and therefore, and they're on a fixed income, they would not have the ability to actually make rent payments, or perhaps there's some sort of money set aside for a family member that has a significant medical condition, and if you liquidated that particular account, you wouldn't be able to take care of the taxpayer with a significant medical condition. Those are the two tax patterns that come to mind when they're for economic hardship. When there is enough money to pay or there is an asset that could be sold, but it would present a significant economic hardship. Okay, then item 7 on the form, offer to pay. Payment in full with offer. We offer a variety of ways to submit your payment. Payment in full with offer, that's the best as far as the controller's office is concerned. Deposit pending acceptance, where you can send in a check or payment and make a deposit on it pending the acceptance of the offer. On our instructions that if we decline your offer, that we will refund it. And I believe that's on next item 8. No deposit payment can be made within 30 to 60 days. $0 offer. It's been my understanding that the IRS requires you to put in an offer of at least $1. We do not. We're okay with without accepting the $1 check. We do accept $0 offers, and often people don't. Taxpayers and representatives don't consider the request for a payment plan. That if they want to strengthen their offer, that they could send in an offer of a certain amount of dollars payable over 12 months, 24 months, 36 months, or 48 months. That it doesn't always have to be what the taxpayer has in their bank account at that particular time or what they could borrow within 30 to 60 days. There is the alternative of saying I'll pay you over 36 months rather than having to borrow from a family, a friend, financial institution, or high interest lender, I would hope not. So there is that offer, and we often do come to the result that maybe a payment plan for a certain amount would be acceptable.
So that payment plan is for the offer itself. It's not a payment plan to pay off the entire amount. It's still
Correct.
a lower offer.
For example, if the tax were $10,000 and a taxpayer offered to pay $5,000 at $100 per month over 50 months, that would be an acceptable offer that we would do in those types of circumstances.
Okay. So you can offer both at the same time? For example, you could say $5,000 and I'd like to pay over 50 months then.
Yes. Certainly an option. Okay, and then item 8, payment will be applied in the best interest of the state. That typically goes to the, based on our computer system, goes to the earliest liability. Payment will be refunded if the offer is declined unless the taxpayer agrees to writing to apply the payment to the balance due. For example, in item 7, if there's a deposit pending acceptance, we will refund it to the taxpayer. I'm not sure if we're unique in that policy or procedure. The taxpayer agrees to waive the right to appeal the tax liability if the offer is accepted. You can't send in an offer, have it accepted, and say, well, you know what, I'd still like to go ahead and appeal that. You do waive your right. You must stay in compliance for 3 years from the date of the acceptance. The taxpayer, our office can collect on the entire amount if the taxpayer defaults on the accepted OIC offer. If they don't send in that accepted amount within 30 or 60 days, or do not complete the payment plan. And I often state that the shorter payment plans tend to be successful. The longer a payment plan is, the more that life may change or the mind may forget about the terms of that offer. And item 9, explanation of circumstances. There is a few lines on our form to write the reasons for requesting an offer in compromise and the facts and circumstances. Some people are able to explain their situation and the reason for the offer in compromise within 4 to 5 lines. Often people do not. That they may put in a significant explanation of the facts and circumstances. My advice, and I think the best practice is to keep your explanation of your facts and circumstances to 1 to 2 pages, perhaps 3 if there's more to say about a particular situation. And I would say that put your most salient facts in the front. Don't bury the lead. If your client has a significant medical issue, if there's a certain financial problem, put that up front and make sure that you bold that particular item. I have seen in personal experiences where there may be a voluminous write-up, 5 to 10 pages. I think that the IRS may require this or may find this to be, more beneficial. But I think that for personal experience, 1 to 2 pages, be brief, be succinct, put your major items and major arguments up front, and I think you'll find a greater success with that format.
Here you go. Is there any difference if you submit a 1 to 2 pager versus just trying to stay within those 4 to 5 lines?
There isn't. With the 4 or 5 lines that are allotted, it honestly depends on the person's writing style. I think that for most things, you may be able to get to those 4 or 5 lines if you use very short sentences and plain language. I don't think there's a difference between the 4 or 5 lines versus 1 or 2 pages. I think there will be a big difference in the 9 to 10 page, or sometimes we've seen longer than that. You do have to think about the resources and the time that's available to the person that's reviewing it, and whether they're going to consider all 10 pages versus the 1 or 2 pages write-up.
I just wanted to add on to that to make sure that when you submit your application, that you submit the 656 and the 433 together. I do get some applications where they come in separately, and it's really important to submit them together. If we receive 656s that do not have the 433s attached, we are returning them to the taxpayer with instructions to resubmit the 656 with the 433. Now also, if you go on the website and you look at the directions for submitting an offer in compromise, there are no directions that tell you to include bank statements or any type of financial information, but frequently our collections department will request that you submit bank statements. So it probably would behoove you to submit at least 2 months, maybe 3 months of the taxpayer's bank statements with the application. It'll just save you time. You won't have someone from collections contacting you and saying, well, we're reviewing your application, would you please send these in?
So the more information you can submit up front and sort of make it easier for the reviewer.
Right. We won't deny the review of an application simply because it doesn't have bank statements, but sometimes we do need to see that information.
Yeah, I think that goes along with the write-up. That if you're putting a salient point there, that this taxpayer has severe medical conditions, maybe attach the write-up from a doctor, something that says, dear reader, I'm telling you this, and then this is actually true, and here's a document that verifies it. Because I know this may be shocking, but I've been lied to before in the office. That people have wrote in things and said that things that were not accurate, and later they'll find out. And then also, if the taxpayer states that their source of income is Social Security disability income, or their own Social Security, or they have a fixed income or pension, attaching 3 months of those statements to it verifies that this is it. This is what I have to offer, or this is what I take in each month, and I have to live off this. So, make your decision based on that.
So then things like medical issues, if you do read that on an explanation, but you have no verification, nothing attached to that, is that something that you will request documentation for, or?
Rarely, but we do have taxpayers that tend to write a history of everything that has ever occurred to them in life, and sometimes it may. I think what we're concerned about is, well, was there a particular medical condition that may have caused the underpayment of taxes, or is there a medical condition presently that does not allow them to actually pay the taxes because they have they're unable to work, or they have expenses for these medical conditions, prescriptions, treatments. And it does help the reader get comfortable with the fact that, all right, this person has to pay for these particular expenses, and if they don't.
So the more substantiation ahead of time, sort of the easier it is for the reviewer to look at the complete picture.
It is to a certain point. So for example, if we receive an application and it's 1 inch thick with medical records, they might have other information in there that's maybe we quite frankly don't see, because they might have medical 4-inch medical records, maybe a few statements about something or an explanation, and then more medical records. And when I say medical records, I'm saying some people are sending copies of X-rays. They send.
We do not want pictures of the outside or inside of your body, which has occurred on several occasions.
So it's not that we're not reviewing all the pages. It's at some point when you've got 20 pages of X-rays, it makes it easier to just get something of significance.
Yeah. Usually a doctor's note, certification, and maybe maybe 2 or 3 pages. That's sufficient. We do not want pictures.
Okay, and yeah, so as we stated before that if you're applying for the offer and compromise, you need to submit the financial information statement, which is the 433A form. I know our slide does say the 433B collection information statement for businesses. We do not accept offers in compromise for businesses that are still viable, that are open operating. So quite frankly, you would very rarely issue a 433B. The only circumstances I can think of where you might issue a 433B is if you have a Schedule C taxpayer. Other than that, I can't.
Some of our business tax collections, sometimes they'll ask for that 433B for a payment plan or a long term, but it's not an often used document at the controller's office. And I know we are perhaps different. Well, we're different than the IRS in many respects, but one of those items is that we do not accept the offers for open businesses. Okay. All right. So, our checklist of when to advise a taxpayer to file an offer in compromise. The taxpayer and the liability, both the taxpayer, the person, and the debt, has to meet the requirements. The taxpayer should not have the available funds to pay the tax in full. The liability is more than 2 years old or written off, and we'll talk about that. When not to advise a taxpayer to file an offer in compromise. Certainly, reviewing the liability and it doesn't meet the eligibility requirements, 2 years. You have unfiled returns. They can pay the liability in full without a substantial hardship. They may be resolved under penalty and interest waiver guidelines. I personally, it does frustrate me, or it has frustrated me in the past, where I've seen an offer in compromise and it was simply for a penalty waiver or an interest waiver that could have been handled by another section. We should try to advocate with our collections group or appeals group for a waiver of penalty or some interest if there's ability to pay, or there's an appealable issue. We have received some offer and compromise applications where it simply stated, I don't believe I'm liable for this. Here are the underlying documents, and we review the record, and the person has never appealed before, and it will be an all or nothing decision.
Okay, and to submit an offer in compromise, you complete the documents, and you can either mail them in to the comptroller's office, and you have the address here. I do want to highlight that it is the Baltimore office and not the Annapolis office. You can also email your documents to cdoic@comp.state.md.us. And if you have questions about the process itself, once again, you can go to the website or you can call us. And the number is listed here, that 767-1555 number.
If you do mail it in or you email in your documents, is there any verification that or confirmation that it has been received? Or
if you send an email, you will get a confirmation that it's been received, yes, an automatic reply. If you mail it in, no, you don't get any type of a confirmation. I do frequently get calls where people are calling to inquire whether or not I have received their application. And we do keep a log of that, so that's something that's easy for me to answer. But do know that if you submit it by mail, it will take a few days to get to me, even if you overnight it. And it's just because of the way our mail process sorting and delivery is handled.
so it might be a good idea then if you were to mail it by certified mail or something, just so that the submitter has something to show that it's actually arrived at its destination.
That's a fair statement.
So that we don't have to keep bugging you about.
Appreciate that. Yes.
Otherwise, people will be calling you
Well, it's funny because even when they send it certified, they still call me because they expect that they might hear something within 2 or 3 weeks. And unfortunately, our turnaround time is that quick.
Are you going to already do the turnaround time at some point?
Yeah, I mean,
What is the turnaround time?
We're working on that right now. I've been trying to get a turnaround time of 4 to 6 weeks, but we do have, this decision doesn't just lie with me or one person. It has to go through multiple departments, and then we're subject to, what people being on vacation, stuff like that.
yeah, I mean, when the application comes in, you do send it to either the individual collections group or the business tax collections group, and they review it and write it up for the offer and compromise board. So, it's always, it could be seasonal, it could be, what volume over there. I mean, in a perfect world, 4 to 6 weeks, but sometimes 30 to 90 days, and we don't like to try to have it go past that. But
And then during that 4 to 6 weeks, is there any indication of where in the process it is, or do we? I guess the question is, do we submit it, wait 6 weeks, and then call you if we don't hear anything, or?
Quite frankly, I would say to probably wait 8 to 10 weeks before you call. What will happen is after we receive the application, and we do not send in, unless you send it via email, any type of acknowledgement. And but then it does go through a process, like Jay explained, through collections, and then comes back down to the case review board after the meeting, and then a determination is made. We will send out a letter to the practitioners and the taxpayer. And so, unfortunately, that's the first contact we have, that we're actually making ourselves. And it's unfortunately just a function of the limitations of the comptroller's office.
Yeah, President, if the collections group reviews the application and it does not meet one of the requirements, and it's typically the 2-year requirement, where there may be unfiled returns, they send a declination letter that says, sorry, you haven't met the eligibility requirements. So that should go out to the taxpayer or the representative.
That's right.
Yeah.
And if that offer is declined because of that 2-year rule, then once the 2 years passes, then the taxpayer can resubmit another offer.
Yes, they can.
Yes.
And they don't even have, in that case where it's not 2 years, say if they have to wait 2 years, but for example, if they submit an offer and we deny it outright, there's nothing that prevents them from submitting another offer. There's no waiting period. Though I have advised people in the past that if they're going to submit another offer, a second offer, they obviously might want to change the terms that they're sending one right after another win, or if there's been a significant change in the financial situation since they submitted the original win, then they really need to highlight that in their second win. Now, I do get calls and people ask, frequently people ask, well, what is the determining factor? And there's not one determining factor in our decision-making process. I also get asked, well, how much should I offer? And I can't tell you that either because it varies. I don't know your circumstances, and quite frankly, I think it'd be a conflict of interest even if I did tell you that. And but what we are looking at is the age of the taxpayer. Once again, this goes back to realistically, do they have the resources, and is this collectible? Based on their age, they might be receiving Social Security, they might have difficulty finding a job. So we're definitely going to take that into consideration. The health of the taxpayer and the family members they're supporting. We know that they might have family members that are disabled or someone with special needs. Maybe they have an elderly parent at home that's living with them. And so we'll take that into consideration. And we do take that into consideration because the health of the taxpayer does affect their ability to make a living or earn income. So that is relevant. The same way with their education, their work history, and their employability, all of those are tied together. and their source of income. Are they receiving Social Security benefits? If that's their only source of income, then they're
Yeah, I often stress that to my understanding, the IRS can garnish Social Security income because it's a federal government, it's a federal payment. You do not have the ability to garnish Social Security income. So if that's the only source of income for a taxpayer, then it's simply not collectible by our office. And I think one of the other difficulties there on that is the location of the taxpayer. The IRS has national offices, and we do not. We're the state of Maryland, and if a taxpayer is located in California or Florida or New York, unless there's our ability to collect on that debt is extremely limited.
We're looking at each other because we have a client in Kentucky with a Maryland tax issue.
And so overall, we're really looking at their living situation, the reason for the tax liability, have they been in tax compliance? Obviously, if they aren't in compliance, then they're not eligible. We look at past bankruptcies, as Jay said, the location of the taxpayer, and also whether or not there's a liens filed, because if we go back to the very beginning, we were talking about that all remedies have been exhausted by the comptroller's office, and I'm sorry, not all. Actually, let me go back to that exact wording. It wasn't that the remedies were exhausted, but the comptroller's office did have to have engaged in some type of attempt to collect, and I think that's just part of our duty under the statute. And so we're going to look to see if any type of liens were filed, and
Let's see. Okay, we've got time running down, so I'm going to go through next two slides and quickly. All right, so once you submit an offer and compromise, it will be reviewed by the case review board, and there will be three decisions. Either one, it's been accepted. Two, the offer is not acceptable, but we would accept a higher amount. You'll receive a counteroffer letter in writing. And if the offer is declined, you will receive that declination letter either from the collections or from what is the rep for the OIC. All of our decisions under the OIC program are final and cannot be appealed. I believe that differs from the IRS. The taxpayer may make a counteroffer if the offer is declined or they do receive a counteroffer letter. And again, they must, if accepted, they have to be current with their filings for the next 3 years. And so that's really the overview of the appeals or the three outcomes: accepted, counteroffer, denied. There's no appeal rights, and but you can make a counteroffer that will be reviewed by the board.
So when you say no appeal rights, meaning that you can't appeal the decision, but you can make a counteroffer.
Correct.
So it's kind of.
And the counteroffer is not to Melinda personally. It's you would send it into her, but she would take that counteroffer and we would look at it at the case review board and determine that. I think you've received some phone calls that, why did you make this decision? And it was not you as a singular human being.
Can we ask why you made those decisions, or would you give us reasons?
I mean, generally, the general reason is that we've reviewed it and we believe that that there is collection potential for the debt beyond what you've offered. There may also be, as one of the factors was, what's the underlying reason for the debt? It may be a trust fund tax, certainly with the sales and use tax and withholding tax that we tend to view differently than an individual income tax liability. And there certainly may have been a fraud aspect to it. We do receive offer and compromise for taxpayers where there's been a fraud penalty, where maybe the underlying facts of it are not advantageous to the taxpayer, or so. Those are our general things. Do we think we can collect more, or there may be some bad facts, or there may be a trust fund penalty?
Okay. And so we can ask and then do a counter offer, possibly based on those facts.
Yeah.
Yes. And so for persons who aren't eligible for the offer and compromise program, they may be eligible for another type of relief, and that's the hardship liability write-off. I do want to stress that the write-off, the debt is not being written off. It's not permanently discharged. It does remain with the taxpayer. The difference is that the comptroller is not actively collecting for the debt. So it's more comparable to what you probably, or well, what tax practitioners are used to with the currently not collectible status that the IRS has. So this liability normally is given for a particular period of time. The hardship liability write-off, unlike the offer and compromise, can be filed at any time. So it doesn't matter how old the debt is. It's an enrollable process, and once again, that decision is not appealable. As I mentioned, the liability is written off the account, but it's not permanently discharged. If there are any tax liens, they remain in place. This is different from the offer and compromise in that if your offer and compromise is accepted, then all the tax liens are released. And any refunds and payments that the refunds and payments are intercepted and applied to the liability. And so what that means is that if you receive a refund from the IRS, or if you're expecting a refund from 2018 and you have a 2016 liability that has been written off, we're still going to intercept that state refund and federal refund and apply it to the liability.
So that liability is not permanently discharged, so it still continues to accrue penalties and interest.
It doesn't accrue penalties and interest. I mean, the penalties and interest will be on the account, but the date that it's written off the account, it will not accrue penalties and interest at that date. But and again, the hardship liability program is a program that we have, and we'll send a request to management of individual collections, and the subject line of the email should be hardship liability write-off, and basically put a short, let's say 1 to 2 page write-up along with a 433A in that email, and request a hardship liability write-off. And it's a program, and I think it's particularly useful for that taxpayer that has a balance due, may have a non-filer assessment, may have unfiled returns, where they might get kicked out of the eligibility requirements because of those unfiled returns. And I think, and in lieu of filing the unfiled returns and starting the clock over again, it may be the best bet to have the hardship liability write-off and have the user money in place. If ultimately that they want to be discharged from everything, the tax lien into the tax liabilities, then they maybe go file the returns and sit and wait if there's sit and wait for the 2 years to pass if there's nothing that we can ultimately collect from the taxpayer. And there's been some discussion, but perhaps if the only liabilities that are out there are non-filer assessments, and they appear to be accurate as far as the non-filer assessment, then I think that we would consider those as eligible for the OIC program. That, I mean, if there's doesn't seem to be much sense in filing an income tax return that simply matches the information on the non-filer assessment of the substitute for a return, if it's just going to end up in the same liability.
Mm-hmm.
But
okay. And then with the hardship liability write-off, is there any statute of limitations for that? That liability to be ever completely discharged?
No, I mean,
there.
there was a recent enactment for liens with a certain time frame from the date of assessment. So, as long as the law allows, I think is the best answer.
Okay, great. So, all right.
Okay.
We have a couple of case studies now.
Okay. Sure, I'll go with this one, and this may be a typical question. Yep, no questions so far. All right, this is a typical case that comes in, and I've advised it since our last presentation to make it less dire. The taxpayer is 66 years old. She lives in an apartment in Maryland. She receives Social Security income of $1,200 per month. Rent is $600 per month. Her expenses match her SSI income. Taxpayer writes that she has severe medical issues. Taxpayer owes $5,678 in individual income tax, interest, and penalty for tax years 1993 and 1994. The income tax due for both years is $1,500. So there's been a significant amount of interest and penalty that's accrued since on this liability. The taxpayer offers $25 to resolve the liability, and the question is, would that offer be accepted? And I would say, unless there's some other facts and circumstances that was listed on the Social Security or the collection statement, that most likely that offer would be accepted because of the age of the taxpayer and the fact that there doesn't appear that, well, because of the Social Security that they've retired, there's no assets to collect on it, and then the expenses match the income, and the collection on it seems well endowed that we'll ever collect anything on it. So $25 is perhaps more than we would ever get on our own volition.
And then the second case study is we have a taxpayer who is 29 years old who lives with his parents in Maryland. He is recently unemployed but seeking employment and owes $1,250 in individual income tax, interest, and penalty for tax year 2014. He owes because he did not have sufficient withholding when he was working as a bartender. He offers a $0 offer and writes that he is currently unable to pay off the liability and wants a fresh start. This is not the taxpayer that we would approve an offer and compromise for. Given these circumstances, he's 29 years old, so he's relatively young. He has many more years of work history, presumably. He lives with his parents in Maryland, so he doesn't have some of the expenses that other people have. He's recently unemployed but seeking employment. When you look at all these factors, it appears that there's still a reasonable collection potential, and so no, he's not a good candidate.
Yeah, I probably would send a decline letter. I mean, if he was working and had some income, maybe there would be a counter offer to a payment plan or for some amount, tax and some interest tax, something that. But yeah, that would be. I know the IRS under their rules would come to a different conclusion, but based on that, that's what we would go to. Okay, so interesting fact pattern here. Taxpayer is 55 years old, lives in West Virginia with his wife and 3 children, works as a general manager at a retail shop, earns $42,000. Mrs. Taxpayer earns $27,000 as a clerk. He had a business, ABC, incorporated in Maryland. However, taxpayer lost his business due to the Great Recession in 2008, moved to West Virginia in 2010. The corporation owed $55,000 in sales and use tax, interest and penalties. A lien has been filed against the taxpayer as an officer. The account balance has been written off by collections. Mrs. Taxpayer was not responsible. There have been no collections on the account since 2009. There was an income tax refund offset at that particular time. He offers $24,000 under a 24-month payment plan to resolve the liability. The sales and use tax due was $22,500. What would be the likely result of our review? Again, without additional facts or circumstances on the 433A or something on the account, that offer would most likely be accepted. It's above the tax due. He certainly does have the potential to continue working. However, due to the taxpayer's location in West Virginia, collection will be difficult. The last collection on the account has been 2009, significant length of time. So given those factors, that would certainly be an acceptable, I'll say it would likely be an acceptable offer. The interesting part about it is, what if the taxpayer offered slightly less than the tax due, $22,500, say perhaps $20,000 or $15,000 or $10,000? What amount, based on his income and expenses, would be acceptable? I can tell you that perhaps below the tax amount of $22,500, based on those factors, may be acceptable, depending on how close to the tax or his income and certainly his income and expenses valuation. So.
Okay, and then this next case study is more like a law school question. The taxpayer is 56 years old. He lives in Maryland and is divorced with one child. He has $250 in disposable monthly income after subtracting his expenses. He works as a manager he has worked as a manager at a retail store for the past 5 years, and his adjusted gross income is $65,000. He had a business, and he's been assessed as an officer of that business for withholding tax liabilities in excess of $45,000 for tax years 2010 through 2013, plus penalties and interest for a total of $90,000 due. A lien's been filed against the corporation and the individual taxpayer, but the taxpayer has not made payment on the account. He offers $10,000 to settle the withholding tax liability and offers to borrow funds from his 401k. This is one of those where there are significant number of factors that we're looking at. One, we see as withholding tax liability, which is a trust fund tax. So that is definitely a consideration. When we look at his age, he's 56 years old. He's a manager, has adjusted gross income of $65,000. So we can presume that he is going to maintain his job and is employable and will continue to receive an income. I will acknowledge the fact that he only has $250 in disposable monthly income. That is definitely a concern. We would consider that. And then looking also at the amount of the liability, the fact that half of it is penalties and interest, we would very likely be willing to compromise on that. And then he's also offering $10,000. So how much of the tax is he actually offering to pay? A big question I have is here, he's willing to borrow funds from his 401k. I think at this point in time, we would definitely need more information on that. We don't know what his assets are. We don't know how much he has in his 401k, if he has any other investments. And so I'm going through this just so you can see our thought process. I know that I'm not really giving you a definitive answer, but in this case, this is definitely something that us and Lex Case Review Board would have this type of a conversation.
Yeah, this is a problem without a clear answer. I mean, as Melinda stated, there's so many factors in this, and this is why I put this at the end. I mean, perhaps do you enter into a payment plan for the $250 in disposable monthly income for how many years? In theory, if it was for 5 years, perhaps you could collect $15,000 from the individual. Is that too long, or is that too short of a payment plan? If he borrows the $10,000, he'll have an income tax liability, perhaps based on his withholding, so then we have another liability. Should you accept the $10,000 as the state, and then put an additional, payment plan for using his disposable income? So this one would be a case for a significant amount of debate, and you would really have to look at the financial circumstances and see what's the best or the best solution to this problem.
And a question about retirement. The retirement, is that as an asset? Is that considered an asset, or is it sort of a protected asset?
Well, I know that the IRS doesn't consider it a protected asset. So that's so we're definitely going to consider that. And but also age is going to be a big factor too. How close are they to retirement? Or are they already retired? You know, what other assets do they have?
Yeah, based on our statutory framework, there is no classification of protected asset versus non-protected asset. We consider it, but again, you think about it and you pull me $10,000 out, what will taxes be withheld from it? Will there be an income tax liability because the government has not withheld? So I don't think you could say that it's a protected asset, but it's a consideration. Should we have that? Should we take into consideration that?
Any questions? So for anyone who has a question, please go ahead and fill that in. But I think we've gone over a lot of stuff here. It's been a very comprehensive review of everything. Thank you so much, Jay and Melinda, for this. And I think the case studies are also helpful to kind of illustrate what's going on. So, again, Jay and Melinda have been very generous in offering to let us post these slides as well as post the webinar for future review. And thank you so much for going over this.
You're welcome. This was helpful.
Okay. Well, thank you, everyone, and we look forward to having you take some cases so you can apply this information. So, take care. Bye-bye, everyone.
I mean, in answer to your question too, I mean, it's feasible that we'll have taxpayers where both of them have pensions, or one has a pension, they're collecting Social Security, and then we also have more. You know what I mean?
Yeah. I was
Bye. You can make this if you share. I'm still sharing your webcam. I don't want to do that. It's usually end here.
that webinar.